everyone and welcome back to our channel. My name is Anda Malescu and I am the owner of Malescu Law, a law firm based in Miami, Florida. Here at Malescu Law, we specialize in serving Florida companies and foreign companies and investors in the area of business, corporate, and immigration law. If you need legal advice or you need to contact us, you have our contact information in this video. In today's video, we are going to speak about the coronavirus impact on temporary employees in the United States that are on an H-1B visa, an E-type visa, L-1 visa, O-1, TN, and other visas. COVID-19 impacts foreign employees in the United States differently based on the visa type they hold and their current employment situation, with some visas being more rigid than others. First, we are going to discuss the impact of layoffs on H-1B visa, E-type visas, L-1, O-1, and TN visa. Generally speaking, layoffs impact foreign employees on these type of visas the same way, meaning that if the company terminates the foreign employee, then the employee loses his or her immigration status and has a 60-day grace period to find a new employment, get reemployed by the same company, or change and extend status. Now, in the case of H-1B visa, E-3 visa, and TN visa, if the employee is terminated, then the employee has a 60-day grace period to find a new employer, and the new employer must file a new petition for the worker in the same visa status. However, it is not as simple to transfer employees in the case of L-1 visa, E-1, and E-2 visas. Another point to mention is that those foreign employees that are currently seeking permanent residence, like a green card, and they are being terminated by the company, then usually the layoff also terminates the eligibility for the green card. Second, we discuss unemployment benefits for those foreign employees who have been terminated by their company and are on an H-1B, E-type visas, L-1, O-1, or TN status. Generally, foreign employees on these visas are not eligible to receive unemployment benefits because their employment in the United States is restricted to working for only one U.S. employer at a time, and they do not have an unrestricted right to work in the U.S. However, spouses of some of the visa holders may be able to qualify for unemployment benefits, specifically those individuals who are on an H-4 visa, an E-1 visa, E-2 visa, or E-3 visa, and L-2 visa may qualify for unemployment benefits depending on the law in the specific state regarding unemployment benefits. With respect to the public charge rule that went into effect on February 24th, 2020, receiving unemployment benefits is excluded from the public charge rule, meaning that if you receive unemployment benefits, you are not considered a public charge. However, immigration officers, when applying for visas in general, may take into consideration or ask about receiving unemployment benefits in order to assess your case. Third, we discuss the impact of furloughs on H-1B visa holders, E-type visas, L visas, O-1 visa, and TN visa status. For H-1B employees and E-3 employees, furloughs are not possible because the employees must be paid the prevailing wage specified in the LCA and the visa petition. In the case of the TN status, where there's no requirement for an LCA, the employee may remain in status while being furloughed if there's a reasonable expectation that the employee will return and work for the same employer. In the case of E-1, E-2, L-1, and O-1 employees, furloughs may be problematic if the employees do not perform any work for the employer. However, if the employees maintain the requirements of the E status, L status, or O status, and continue working for the employer and will be rehired within the 60-day grace period, then there's arguably no issues with furloughing these employees. However, if there's a substantive change in employment for the E1, E2, L1, and O1 visa employees, it is important to notify USCIS immediately or seek guidance from USCIS or file an amended petition. Fourth, we discuss the impact of salary reduction and reduction in the working hours for employees that are on an H-1B visa, E-type visas, L-1, O-1, or TN visa. For those foreign employees currently on an E1, E2, L1, O1, or TN visa, a salary reduction or a reduction in the working hours by the company is permitted as long as there is no material change to the terms and conditions of the employment. This means that if there is a material change, such as the employee went from being a full-time employee to a part-time employee, then it is important to notify the USCIS of the substantive change and seek approval. For those working visas that require an LCA, such as the H-1B visa and the E-3 visa, a salary reduction or a reduction in working hour is not permitted usually below what is specified in the LCA. Otherwise, the company must file an amended petition and obtain a new LCA. Fifth, we discuss the impact of temporary remote work or working from home for those employees that are currently on an H-1B visa, E-type visas, L-1 visa, O-1 visa, or TN visa. For those foreign employees with an E1, E2, L1, O1, or TN visa, temporary working remotely does not impact their immigration status as long as they maintain the requirements for their visa. For those employees that are on an H-1B and an E-3 visa, which require an LCA, they're subject to notice requirements for the working location, for the office location, and for them working remotely is possible if the new location is within the metropolitan area of their usual office location, and they maintain their notice requirements and post notice for 10 calendar days. However, if the new location is not in the same metropolitan area as the usual work location, the new SEIS, due to COVID-19, has relaxed the rules, and it is possible to do so for 30 or 60 days if the requirements are met. Otherwise, the employer must file a new LCA. Thank you for watching. This is all for today. Please subscribe to our channel, and if you need to contact us, you have our contact information here in this video. See you soon. Bye.